Hear ye, hear ye. The Court of Appeals for the First District of Texas is now in session. Pursuant to adjournment, God save the Constitution is on the court.
Good afternoon and welcome to the virtual session of the First Court of Appeals. We have one case on today's docket, case number 0119-00302-CV. Hikom Watanabe versus Summit Path Partners, LLC, Hossein Aitomohand, AJ Ahmed, and Edward Hua. May I have the appearance of counsel for the appellant, please?
Reginald McCamey for appellant Hikom Watanabe.
And my understanding is that you're going to speak for 9 minutes and reserve 6 minutes for rebuttal.
That's correct, sir. That's correct.
And for the appellees, we have appearance of counsel.
I'm David Points for appellees, AJ Ahmed, Edward Hua, EABBC Payne Law Firm.
Kyle Giacco for appellee Summit Path Partners, LLC.
Thank you very much. As soon as the clerk works his magic, you may proceed, Mr. McCamey.
Yes. May I proceed?
Yes, you may.
Oh, thank you, Judge. I'm proud to represent Mr. Watanabe, who was attacked going to the aid of an employee of one of the appellees here, Mr. Hossein Aitomohand. And the issues presented for the court, or whether the trial court erred in granting summary judgment in favor of Hui and Ahmed in their individual capacities, whether equitable tolling defeats EABBC LLC's affirmative defense of limitations, and whether the court erred in granting summary judgment to EABBC on any other asserted grounds. Fourth, whether the court erred in granting summary judgment to Summit Path Partners LLC, and whether the court erred in granting summary judgment to Hossein Aitomohand. First, I'd like to address in the record that Mr. Watanabe was not a trespasser, and I think that will take care of a lot of things. In the court, in the clerk's record at 509 and page 107, line 12 to 19, Mr. Watanabe tells why he went to the parking lot to assist the employee of that parking lot. He says, I heard Samsung, I heard yelling, and I was just across the street, like from here to here, and I saw Samsung, the manager of Hossein, surrounded by 4 guys. Wait, I'm sorry, there's a question. Wait, I'm sorry, the manager what? Of the self-parking, Samsung, they call him Samsung. Mr. Watanabe was going to assist the manager of the other parking lot. He was not a trespasser. He was not an interloper. He was there to assist his friend and worker, Samsung, that he worked with from time to time. Now,
Mr. McCamey, can I ask a question?
yes.
Did the plaintiff park the assailant, Mr. Williams' car? Did Mr. Williams use the valet service that was there with the Knox Club, or did he park on a lot operated and run by someone else, some other business?
It is my understanding that he parked on the lot that was run by Mr. Aitomohand. That was not owned by Knox. That was leased by Aitomohand from Summit Path.
And did the plaintiff use the valet service, or with the plaintiff's valet service, or did he just self-park his car over there?
I'm not sure whether he self-parked his car. It was not unusual for people that went to Knox to park at the parking lot across the street. It was not an unusual activity. So I want to go through some undisputed facts. Hikom Watanabe was working for someone on the date of the incident. record at 488, page 23, line 4 to 14. There was no verified pleading for the defense of capacity pursuant to Texas Rules of Civil Procedure 93. Summit Path leased to an entity other than EA BBC LLC, and that's in the clerk's record 449447. Summit Path and Hossein et Mohand had no written agreement. They only had an oral agreement that said at Mohand could use the lot for certain periods of time. That's in the record.
Jamie, let's focus on the premises liability claim.
Yes.
So the property where the assault occurred was owned by Summit Path, correct?
Correct.
And at the time, it was under the control of Mr. Aitmahan pursuant to a lease?
Not exactly. They granted Mr. Aitmahan a lease for a certain period of time. Summit Path retained control. If you look at the record in the record, clerk's record 470 and 472, you will see that Aitmahan did not have exclusive possession of the premises. He could only use it during certain hours. So Summit Path never released full control. They retained control of the premises.
It seems that they controlled the premises during the daylight hours, and Mr. Aitmahan controlled it during the nighttime hours when the nightclub was open.
Well, that's what they have said. I think that is a disputed issue in terms of what control that they had even during the other hours. There was no written agreement. This was all oral. So this is what they said orally. There's no written agreement. There's no contract. There's no lease. And of course, to escape liability, they may be saying that, but there's nothing that says that. And so
Okay,
we go to
so,
the credibility.
so we have a property, and you contend that there's a fact issue about who controlled it, whether it was Summit Path or Aitmahan at that particular moment.
Absolutely not.
Right now, let's turn to Mr. Watanabe. Right?
Yes.
You said that he's not a trespasser. Was he an invitee? Was he a licensee? What was his status at the time?
He was an invitee. He had been going over to that lot from time to time. He was going over to assist the employee that was there for Aitmahan. So he was not a trespasser. And I think he would be best described as an invitee going on the premises to assist someone that was on the premises in need.
For his own purposes, correct?
No, not for his own purposes. That benefited Aitmahan. It did not benefit him at all to go over there. He saw a person in need that was employed by the person that was leasing the premises at the time. So that was not for the benefit of Mr. Watanabe. He got no income from that. His only
well, is it to be an invitee? Does it have to be income to Mr. Watanabe? I think if you read the definition, Prosser and Keaton, it's anybody taking a shortcut across the property, loafers, loiterers, servants, spectators, sightseers, tourists. As long as it's not for, invitee requires mutual benefit.
I understand.
Right. So what benefit inured to Summit Path by Mr. Watanabe going over there?
He was stopping a crime happening on the premises. Prior to that time, there had been 10.
How does that benefit Summit Path?
Because then Summit Path would not be liable for any injuries to somebody that's on the premises. He was trying to stop what was going on from happening. And if he had stopped it, then Mr. Samsung would not have been injured. He would not have been injured. So that is, why a mutual benefit of him assisting Mr. Samsung. Clearly.
Mr. McCamey,
Yes.
That excerpt that you read at the beginning of your argument, did you present that to the district court in your response to the motion for summary judgment or motions for summary judgment?
We did, Your Honor, we did. That was presented. That is the issue, is that Summit Path never released entire control of their premises. And so they had an obligation and a duty to make sure it was safe. They knew it was hazardous there, and my time is up, and I'll finish when my last rebuttal.
Thank you, Mr. McCamey.
Judge, can you all hear me?
Yes, we can hear you. Please proceed.
All right. Judge, I'm going to go straight to, if you all allow, I'll go straight to the issue of the premises liability issue. On September 1st of 2017, we presented our traditional motions for summary judgment. We also presented our no evidence motion for summary judgment. Appellant never responded to our no evidence motion for summary judgment. But in that judgment, I want to make sure I go through the factors that I believe all of us were dismissed on. When I say all of us, I mean all defense were dismissed on. That's the Timberwalk factors. First, let me go through the evidence that appellant has stated that were the issues at the time. The first one was that there was a history of violent crime in the area. He also had an expert of Mr. Bell's opinions. And he also stated that there was a lack of proper lighting and adequate security. So with that being said, there's a longstanding rule in Texas regarding Timberwalk that a person has no legal duty to protect another from the criminal acts of a third person. With that being said, we can go back to the day of question and the deposition of Mr. Watatambi. I'm not sure if I said that correct, but in his deposition, he states that he was working. He hears commotion across the street. He goes across the street to help Samsung, as Mr. McCamey has stated. What happens is there's testimony that states that the manager, Hassaman, was not there. He left at 1:30. He saw Samsung standing there with the commotion. Mr. Williams and his acquaintances tell Samsung, let's step to the back of the parking lot to check out the car. Samsung says no. Of his own doing, plaintiff Watatambi says, okay, I can work this out, take me back there. So not only do you not have a manager there, the attendant manager that was working there decided, hey, I don't think this is a good thing. I'm not going to go back there with them. Watatambi goes back there with them, checks them out, they're talking, and in that time, an assault happens. Now, it's a situation where a question of lack of proper lighting and security. And there's no evidence to show that proper lighting or adequate security would have helped the situation. This was an unreasonable, this was a situation that it was an unreasonable crime, and he just happened to be a victim of this crime. There's no evidence that shows that anything would have stopped this crime from happening. Secondly,
is that his burden to show that had you done those things, the crime wouldn't have happened? That's a pretty high burden.
It's a pretty high burden, but it's a factor to consider. And so, and as I go through the other factors, there's a factor as far as violent crimes that the appellant talks about. He submits that there are certain things or crime from the Harris County Public Records. This actually going through, let me pull this up, some of the things from the Harris County I was able to go through. For the past 3 years, there was not much going on as far as something that would relate to this specific incident. And as far as with Timberwalk, you have to have some kind of similarity as far as these crimes. Because if you just have crimes going into the area with this specific crime happening, you just have to take a look. You have a crime, you have domestic violence here, you have an assault here, and these were all in just 2 instances in 2012. You have one instance since 2010 with an assault. There's a domestic violence issue in 2011. There's no specific happening of this nature that a manager should have been aware of. Lastly, the duty that Ahmed, EABBC, and Edward Hua, there was no duty. As we saw, the defendant, we don't even know whose parking lot it was. The defendant was doing his job, goes across the street to the parking lot to assist someone in a commotion that happened. There's no duty that exists as far as the appellees, excuse me.
Mr. Boyce, can I ask a question? Does it make a difference in the plaintiff's status as to whether a invitee or a trespasser that he crossed the street voluntarily, not to park cars, but to inject himself into some dispute that was going on that portion of the premises? Does that affect his status?
No, not at all. And I think appellant's brief is kind of a red herring to, kind of talk about whether this is an invitee or a trespasser issue. There's no issue whether he was an invitee or a trespasser. He brought himself to this situation. It's even in the deposition, he says that, hey, the police patrolled the area from 10 to 2:30. He's not sure what the exact time that this happened, but he's saying it's between maybe 2:30 or 2:40. Everything was on the premises. Even after the assault, Waterby came back to work. He came back to work, and the only reason he ended up quitting the job or ending the job is because he got into a dispute with one of the managers. So I believe it was a safe environment, whether he was a trespasser or an invitee. It doesn't matter. There was no duty to provide for that kind of unreasonable situation or criminal activity. So with that being said, let me also go back to the two issues that are before the premises liability regarding my appellees. You have equitable tolling. It's a situation where appellant did not name or sue the proper party. Those things could have been easily discovered in discovery. Appellant never filed a request for disclosure. During that time, we didn't have to just give it straight off. It was never requested. The trial judge requested it. Also, to go back to a situation of, the affirmative defense, we have until 7 days before trial to submit our affirmative defense. We did that. So in our motion for summary judgment, we asked for an affirmative defense because in their individual capacities, Hua and Ahmed were not the owners of Knox nightclub. Even in addition to this, we see a situation where Mr. Waterby goes across the street to the parking lot for the premises of someone else. Mr. Hua, Mr. Edward, Mr. Ahmed had no idea that there would be this kind of attack on him. That's my time. I know I have Cal behind me, so I'll reserve my time for Cal.
Thank you, Mr. Boyce.
Good afternoon, Your Honors. My name is Kyle Giacco, and I represent Summit Path. I wanted to answer a couple of the court's questions with a little more detail. With regard to whether it makes a difference whether Mr. Watanabe crossed the street voluntarily versus parking his car, with regard to Summit Path, absolutely. If he was on the premises having parked a car there, he would have been a customer of Mr. Eight Mahand, and at least as to Mr. Eight Mahand would have been an invitee. Here he was on the premises not for the benefit of either Mr. Eight Mahand or Summit Path. He instead just entered the premises, and therefore he is in no way, shape, or form an invitee of either entity. It is our position that Summit Path had turned over control. There is evidence within the summary judgment record. It is an affidavit of our client stating the details of the agreement of turning over. There's no dispute Mr. Eight Mahand was operating a self-park business that Mr. Williams had paid to be on that lot, but not Mr. Watanabe. Mr. Watanabe was crossing the street to interject himself in an argument. There was no ongoing assault. Whatever conflict had started, he then went with Mr. Williams and his friends, leaving Mr. Samsung behind. So any danger to Mr. Samsung had ended, even if his initial justification, which would not have made him an invitee, at most would have made him a licensee, if he had gone over to help someone. But once Mr. Samsung has left the picture, he stays behind. And it is just Mr. Watanabe going over and talking to Mr. Williams, who is an invitee on the premises of Mr. Mohand. Therefore, he is not in any way, shape, or form an invitee of Summit Path. Summit Path is not in control of the premises. It had turned it over at the time of the incident.
Can I ask you about that? The records seem to reflect that Summit Path only leased the premises, like Justice Kelly was saying, during the nighttime hours, but would have still retained control, let's just say, during the daylight hours. Is that correct?
Yes, Your Honor.
So as far as exercising control, I know one of the issues is a lack of lighting. Would they not have had control of the premises to the extent that they could have modified or increased the lighting on the premises?
Theoretically, Your Honor, yes, though their duty to provide security would only have to be reasonable as to when they exercise control. If Mr. Mohand had a duty to provide security to his invitees during when he controlled, the issue of lighting would fall on him. But here, all of that is irrelevant. I did want to address Justice Landau's question, because the issue of whether the security would have benefited Mr. Watanabe is absolutely relevant under Texas Supreme Court precedent. Western Investment versus Arena, 162 Southwest 3rd, 547, is in our brief. It involved the sexual assault of a minor in an apartment complex. The resident, the person who conducted the assault was a resident. They said in that case, there was no evidence that increased security would have prevented the accident. There's no evidence of proximate cause, which is one of the prongs that we've raised in our summary judgment. Here, Mr. Williams is absolutely on the premises for right. There's no evidence that the lighting would make any different. Mr. Watanabe was perfectly aware Mr. Williams was there. He was talking to him. There's no evidence in the record to show how more lighting would have affected anything. No evidence in the record to show how increased security. Everyone, particularly Mr. Watanabe, was surprised by this attack. So no security, there's no evidence in the record to show that security would have made any difference whatsoever. And that was their burden, and it's stated explicitly in Western Security, where that was or Western Investment, where they specifically held and sustained a summary judgment because there was no evidence increased lighting would have prevented the crime. That was the specific holding of the case. In addition, with regard to the Timberwalk factors, there is no evidence that this was a foreseeable crime, because while they put on an affidavit and an expert that said this was quote unquote a high crime area, he did no analysis to do the factors regarding similarity or proximity. And the crimes they looked at were up to more than a mile away. He doesn't delineate which crimes he's looking at, and there are no similar crimes to effectively is an argument of some sort where they're interacting. This is not a robbery. This is not an assault of an unknown person. This is an interaction between Mr. Watanabe and another person who, I guess, escalated. We don't know all the details, but that's not a foreseeable crime. He is not a foreseeable victim. He is not a client. He has interjected himself into this situation. And to the extent he justifies it, that's fine. But certainly that situation with regard to Mr. Samson had ceased. He's the one who chose to go over. And I'm not making a comparative fault argument. What I'm saying is his status on the property at that point is not to the benefit of anyone of my clients, or Mr. Eight Mohan, who had the lessee who was actually in control of the premises.
How does the evolution of the situation work here? So it sounds like he at least initially approached to help somebody who was, working for the renter. And then you're saying that as the situation evolved, he was no longer helping.
With regard to his status, I would say that the situation, the way the evolution is, you look at the purpose that the person has entered the property or is on the property, and you can cease to be an invitee if the reason why you're there has changed. He wasn't an invitee to begin with. I think involuntary crossing over at most would have made him a licensee, and I'm not even sure that would be the case. But assuming he was even a licensee, once he's not going over for the benefit of someone who has a right to be there, he is just on the premises as a trespasser. He's not there for anyone's benefit. And I would also like to point out in Del Lago, to the extent that this was an escalating situation, if someone tried to make an analogy to Del Lago, they had to show actual knowledge of an escalating situation. And my clients were, the evidence is quite clear that my clients were not present and had no knowledge of whatever situation occurred. And I am out of time. If the court has any other additional questions.
No further questions. Thank you, Mr. Giacco.
Yes, I'd like to just talk about a few issues. First, Justice Landau, if you look at the record, the clerk's record at 510, you will see how it progressed. Page 110, he says during his deposition, they were really mad, and they asked Samsung to follow them, and he said no. And I said, guys, can you just show me the car? I might help you. I mean, we're going to fix you. The owners, the owner club and Hossein, they can fix that for you. So no worries. So I took him away from him because they were really, the way how they were talking and the way they were mad. So he was taking them away from Hossein's employee, assisting this person, and no benefit to him. Now, the question of whether they should have knowledge, whether Summit Path should have knowledge. Summit Path itself acknowledged in the record at 474 and 481 at least 10 similar types of crimes in the 3 years prior to Watanabe's assault. That's in the record at 474 to 481. So they had knowledge, even though they leased it to.
Is that an unreasonable amount of crime?
Excuse me?
Is 3 assaults per year in that area of town, is that an unreasonable amount of crime?
I think so. When you look at it, it's on that specific vicinity. It's not like a mile away or anything like this. These are crimes they admitted to. Now, Sergeant Bell, the police officer, showed many violent crime incidents in the area. So these are 10 that Summit Path were saying, hey, we know about those. So if you got about one violent crime a quarter, then you need to do something with your lighting. And Sergeant Bell said that lighting would have helped. Contrary to what opposing counsel just said, we did provide information in the record for the trial court to know that the lighting, better lighting would have helped. And some of these things were fact questions for the jury. It's a fact question, between Mr. Bell and whoever the opposing counsel would want to get to say, that it's not a serious issue. But those are fact questions. So I think all of the checkoffs for the landmark case, Timberwalk, are met. I think you have proximity, you have the crimes, you have similar crimes. So I think all of those are met. As far as the equitable tolling, this should not be gotcha law when people's lives are at stake. It is clear that that the opposing counsel perhaps laid behind the log. They never, as required by Texas Rule of Civil Procedure 93, came forward and said, hey, a verified affidavit saying we're not the right party. We're not the, you should be going after a corporation, not us. And so they waited until after the statute of limitation. And so equitable tolling would allow this plaintiff to have his day in court with these facts.
Was discovery served on them or request for disclosure?
Discovery was served on them. I can, as I sit here, I cannot recall. They have alleged that we did not ask them for whether it was the right party or whether it was a corporation, but they never filed it. And I think you can infer that it was done to wait until the statute of limitations ran on EA BBC LLC. The other thing is, I think it's a fact issue whether EA BBC LLC is even a corporation, not a sham. There are no 1099s, there are no records, there's no contracts between any parties. And I think that is an issue, whether they were even in, they had nothing other than a corporate formation. So we don't even know if it was a solid corporation.
Mr. McCamey,
Yes.
did you present the equitable tolling argument to the trial court?
I believe we did, Judge. Justice, I cannot recall exactly. That's been 3 years, but I believe we did present that to the court.
Mr. McCamey, a question I have, it's kind of a procedural thing, but is the plaintiff's third amended petition the last petition that's on file
Yes, I believe it is the last petition.
in this case?
Yes.
Because I don't see EEA BBC as being a party to this lawsuit in plaintiff's third amended petition.
Okay.
I just,
I believe
don't
that
know.
is, it's been several years since we did the case, and I just can't say for sure whether that's the final one or not. I believe we did bring them in after we found out about them, but so that may not be the final petition. I'm just not sure.
Okay, thank you.
Yes. Thank you, justices, for your time.
Case number 01190030 CV is now submitted, and the First Court of Appeals is adjourned. Thank you for your time, gentlemen.
Thank you, guys.
Thank you,
Your Honor.
Justice.